Hello, good afternoon, and thank you very much for your opening statements there. Okay, I suppose there's a number of issues now. The Centre of Disability Law and Policy with NUI will just address the issue one there. The process of which these amendments have been developed has not been an inclusive one. That's been pointed out. There's no public process organised by the Department to engage with disabled organisations in the development of these heads. There is no plain English or easy-to-read version of the text available. It is not made accessible to them. So the issues of accessibility of legislation is one in which needs to be addressed. How do we propose to do that? And obviously, we need to engage with the disability sector in order to do that. So I suppose how best do we do that? Issue number two there, the amendments may appear minor or technical in nature. And this is the increasing bureaucracy of support and creations of assisted decision-making industry. The amendments will be made make it more difficult for a person to designate their chosen decision-maker. So how do we address that? That's another issue. How do we address that? How can we make it easier for the person to designate their chosen decision supporter? The amendments put forward are not more ambitious in terms of human rights compliance, enabling the disabled person to sit as members of juries. The amendment also does not address the need for further resources to be provided to give effect to the decisions people may make. So that's very concerning. Those are very concerning. The issue from the Mental Health Commission was extended by the Assistant Decision Maker to include the establishment of the new Decision Support Service. It's in your view that the Mental Health Commission is more compatible home for the DSS. Is that where it should be located? Is that where it's currently located? Or is that where you'd like it to be? It's more compatible to home for the DSS. So that you're looking obviously to remove the courts, compatible with the courts where it's currently, or you want to relocate that? That's what I want to know. We must emphasise the access to the supports available under the 25 Act cannot be withheld from persons in the mental health setting. That's another issue. Once the decision, this is for Adam. Once the Decision Support Service becomes operational, people with capacity difficulties will have access to the agency mandate to enable them to avail of these new decision supports. According to the general scheme process to remove these provisions from the 2015 Act, safeguards are also being strengthened where a decision supporter abuses his or her position. It provides for the courts for an order temporarily prohibiting somebody from acting as a decision-making supporter pending the outcome of an investigation. The scheme also provides for an offence of ill treatment or willful neglect of a relevant person by a decision supporter. It also provides for the incremental doubling of the percentage of people with disabilities employed in the public service from the current 3% to 6% by 2024, which is welcomed. Increase employment opportunities for people with disability, which is always welcomed. The scheme to amend the Electoral Act to remove the prohibition preventing persons of unsound mind from standing for Dáil elections. It also proposed to amend the Juries Act 1970 to enable people with specified disabilities to serve as juries. Sorry,
Senator Keogan. Can you just be a bit more specific in your last question?
I suppose really, I'd like them to broaden those particular issues there that I have.
Just in your last questions there, in particular, can you just be a bit more specific? I think in relation to the questions for the Irish Human Rights Equality Commission, because there's a lot you're saying, a lot there. I'm not sure if it's fully understood what the question is.
The questions, right? Okay. Okay, we would like to ask May first, in respect of the original legislation, in line with the CRPD obligations, every opportunity is afforded to the wide range of stakeholders, particularly people with disabilities, to meaningfully participate both in pre-legislative scrutiny. It is very important that the disability sector are included in this. But how are we going to do that unless we do it with regard to, unless we do it in plain English? So I want to know, is that going to be done? Will the disability, those that are affected by this legislation, be able to access it in plain English? So that really is what it boils down to, because this legislation does affect the people with disability, and it affects their wards of court, and it's really important that they understand it in plain English.
Okay, we'll take that question, and then I know there's questions there for NUIG and mental health as well.
Okay, go on ahead.
Yeah, so do you want to come in first, Adam, and then I'm going to go back to NUIG and mental health as well.
Thank you, Chair, and thank you, Senator. I think your question really covers, I think, the heart of what we're discussing today, and it's the involvement of people with disabilities right throughout this process, from the legislative process that's happening now and the pre-legislative process, but also actually what will happen when this legislation comes into effect as well. So I think, first and foremost, it's very important to understand that the state under the UN Convention has an obligation under Article 4 to actively and proactively engage with disability representative organisations and disabled people. The UN has interpreted that in some detail in General Comment 7, and this looks at the sorts of reasonable accommodations that the state needs to make in its consultative processes to ensure that the voices of disabled people are at the heart of the process. The Commission will be very happy to circulate a copy of General Comment 8 to members of the committee after today for your information. But I think when we look beyond that as well, what are the implications for disabled people in this regard? I think one of the things that is important to realise is that this is the start of a 3-year process. And one of the things that's very important from an IREC perspective is that we're clear that how are wards going to be communicated with during this process in terms of the journey from the wardship system towards this assisted decision-making system. But furthermore, limited to that, I suppose what we are concerned about is the limited nature of appeals that seems to exist when that is compared to the Mental Health Act. In addition, the lack of clarity around what right to legal representation wards will have, and in addition, the time frames that will enable a person to be detained, which again are less clear and less specific at present than what are in place with the Mental Health Act.
Thanks very much, Adam. So either Eleanor or Cliona, did you want to come in on the questions there that were put yourselves?
Yes, thank you. So just on the, I suppose on the point around consultation, we appreciate there's a tight timeline involved, and of course there's a shared desire to commence the Act as swiftly as possible, given how long people have been waiting it. However, we feel very strongly, as has been said by other witnesses to the committee, that it is not too late for the department to undertake a more comprehensive and meaningfully inclusive consultation with those who are directly affected by this legislation and by the amendments contained in the proposed heads of bill. And that can be done in a number of ways. It can be done starting with some of the groups who presented yesterday, but extending beyond them. There are different means in which the department can engage with people, and we would certainly encourage them to do that before bringing forward the final bill to Parliament. In terms of the examples of the bureaucratisation of support that we're concerned about, I'll give you a very clear example in Heads 3 and continued in Heads 38 and 60. In the amendment bill, there is a proposal to remove the opportunity to include decisions about healthcare treatment in enduring powers of attorney. So that would mean that if I want to create an enduring power of attorney and I also want to plan in advance for my healthcare decisions, I will have to create not one instrument but two. I will have to create an enduring power of attorney and an advanced healthcare directive. And because I will have to create two instruments, I may have to then get two separate requirements for supporting evidence. I will have to have witnesses again for each instrument. I will have perhaps to have separate assessments of my capacity to make both instruments, since capacity is to be assessed in a decision-specific manner under the Act. And this is especially burdensome if the relevant person would like like to authorise the same person that they're granting power to under their enduring power of attorney as their designated healthcare representative in an advanced healthcare directive. So again, while people should be free to create two instruments if they wish, we're very concerned that the Act is making this distinction and not allowing people the freedom that they would like to have to decide exactly how they would like their support to be provided to them. So that's just one example of the bureaucratisation of support. In terms of the need for legislation to be made available in easy to read, there are several precedents for how this can be done, and my centre and other groups have expertise in supporting the development of easy-to-read documents. And for example, in England, the Mental Capacity Amendment Act of 2019 was developed in an easy-to-read version. So even on capacity, we have some good examples of how this can be done on this kind of legislation specifically, even though, of course, the legislation itself is complex and it takes time to explain it in an accessible manner that also retains the accuracy of the legislation. So I think I will leave it at that for now, and I'm happy to come back if the Senator has further questions for us.
Thanks, Eleanor. John, are you coming in, or Anya on the Mental Health Commission?
I'll come in first and then I'll pass to Anya. So, Senator, the DSS has been in the Mental Health Commission for a number of years, but we haven't, this Act will give us full effect to the functions. So we've been building the service for a number of years, and why we think it's compatible is that we had the same exercise a number of years ago in making sure that people with mental health issues rights were vindicated in an arena where there's professionals, where there's a lot of people with a lot of power except them. So we have a very particular attitude to making sure a space is cleared for people so that they can exercise their own powers and we can support them. That's with people who've been detained. In relation to the mental health specifically, I'll defer to Anya, the Director of the Decision Support Service.
Thanks very much, Chair. If I might come in there. Yes, as we have dealt with in our submission, and my colleague John Farrelly has referred to in the opening statement today, we are very keen to see a better alignment between the mental health legislation and the Assisted Decision-Making Capacity Act. We refer in our submission to two aspects in which we think this is important. And Professor Flynn has referred also to the removal of the viability of an advanced healthcare directive where somebody is detained under the mental health legislation. The Mental Health Commission, the DSS, has been very consistent in saying that that's discriminatory, it offends against parity, and it should be removed. But I understand that that is receiving attention. Other concerning section in the Act, Section 136, which effectively disapplies access to the supports under the 2015 Act in the mental health setting, but I believe that that also is receiving attention, and we hope that it will be amended in the final version of this legislation. Chair, if it's opportune or appropriate to refer to some of the matters which have come up in other colleagues' answers today, but perhaps in relation to the access to legal representation, which I know that Mr. Harris raised, there is provision in the Act for access to legal aid for the relevant person who is the subject of an application under Part 5. And I think Mr. Harris has referred also to some aspects of Part 10 and the detained ward, and I understand that that part of the Act is also receiving attention. In relation to wards more broadly, the review of their circumstances under Part 6 is the responsibility of the Office of Wards of Court, but I know that they've already begun to engage with communications with those current wards, who number about 2,150, and that will be ongoing as their review continues, but that's with the Office of the Wards of Court. I'm in a position to pick up on the point about the excessive bureaucratisation as exemplified under the removal of medical and treatment decisions from enduring powers of attorney, if I may, and merely by way of clarification. That wasn't one of our own submissions, but the idea is not to create obstacles, but rather to promote clarity. At the moment, when it's possible to plan ahead in terms of healthcare by way of an EPA and an advanced healthcare directive, there was a concern that the two aren't necessarily aligned in terms of the protections and the requirements under Part 7 and Part 8 of the Act. Also, an enduring power of attorney at the moment, as the Act reads, can't extend to a refusal of life-sustaining treatment, whereas an advanced healthcare directive can. And I think it was with that in mind that the decision or the submission made by other colleagues was it better if advanced healthcare planning around medical treatment was confined just to an advanced healthcare directive, not to make things more difficult, but actually to make them smoother.